Well, good morning, everyone, and welcome to this month's webinar. This month's webinar is kind of a roundtable discussion based on your questions that you've submitted to us, and thank you to those who did submit the questions. We're going to hear today from myself, Adrian Bailey, Kate Chalker and Kimberley Barnes. Adrian and Kate work in our Sydney office, and myself and Kimberley work here in the Brisbane office, although Kimberley does a fair bit of work for Adrian and Sydney clients. So a lot of the Sydney-based people will know Kimberley. So yeah, again, thanks for all the questions. We've got probably about 17 questions, although one or two of them are kind of linked to the same sort of topics. So we hope to get through all of those today. Just to run you down on the system, for those who don't know, you can download the slides as a PDF. You should see a files button there that'll let you download the slides. If you've got any questions, please put them into the chat box and we'll monitor those as they come through. And obviously, if they're about a particular topic that we're talking about, we'll try to jump in at the right time. If not, if they're about something completely random, that's fine too, and hopefully we'll get to those towards the end. After the session today, there'll be a feedback survey that comes through. It's a short, simple survey you'll be able to download some of the materials as well if you can't work out how to do them on the system. So we're going to start off today with a question that Adrian's going to take, and I'll lead off with him.
Thanks, Paul. Hello, everybody. Welcome to the webinar today. So this is the first of the questions that were submitted prior to the webinar. As Paul mentioned, if you want to submit some via the chat function, send them on in. But the question is, perhaps one matter that could be raised is the subject of section 290.150 and 290.170 of the 1997 Act. The requirements, and in particular timing issues contained in these sections, are very strict. Many coalface accountants are not fully conversant with these sections, often paying lip service to the requirements that see Canna versus Commissioner in Taxation. For those of you that don't know section numbers, and I must admit I'm not one that memorises a lot of them, 290.150 and 290.170 deal with whether a personal contribution to superannuation is deductible and the requirements of that. Those particular provisions relate to the notice requirements. So if you're wanting your contribution to be deductible, you need to give a notice to the fund in relation to that. Now, there are some strict timing requirements within the provisions that say that the notice needs to be given either on the day of lodgement or by 30 June in that following income year that the return is lodged. So say, for example, if we lodge our return in May 2022, we need to either give notice by the date that we lodge or by 30 June 2022. If notice isn't given and also an acknowledgement has to be received from the trustee of the super fund, then the amount is not deductible. There is no ability for any form of discretion in terms of that timing provision. So it is the case, and certainly that case of Canna showed that there's no ability to extend that time. If you're not in by that time, if you haven't given notice, then you fall out of the provisions and it's not deductible. So something to bear in mind, of course, and something that perhaps should be on your checklist, I guess, in terms of making sure that when you're lodging returns, either the notice is going in at that time or you're being clear with your clients that it needs to be by the 30th of June of that year. I'm going to throw over to Kate, who's got the next question.
Thanks, Adrian. So the next question I have is from Blair Wilkes. So thank you very much for your question, Blair. The question is, I've got clients who run a small farm. The husband works in the mines half the year and on farm the other half. They've sold part of their land and want to use small business CGT concessions, but I'm worried about whether they pass the active asset test, mainly the business test. So looking at the legislation on active assets, in order for a CGT asset to qualify as active, it needs to be owned by the taxpayer and either used or held ready for use in a business which is carried on by the taxpayer or one of their affiliates or connected entities. I don't think there's any issue in terms of the active component of the definition, because either the property would be used to carry on the farming business, or it will be held ready for use for when the client comes back from the mines and is carrying on that farming business for that half of the year. But I think you're quite right, Blair, in that a question could be raised by the ATO as to whether there is an actual business being carried on by the taxpayer. And often when we get these types of questions, there is a fair bit of grey area, and it's often difficult to come to a definite opinion because it really is a question that is based on a number of different factors provided by the Commissioner, and none of them are decisive on their own. So it's a matter of looking at all of those different factors and weighing them up as a whole as to whether there is a legitimate business being carried on by the taxpayer. So I think in this case, given that the farm is only run for 6 months out of the year, there would need to be some kind of evidence or something to show that despite the fact that it's only been running for half the year, there is still that commercial intention. There is that intention to derive a profit from the 6 monthly farming operation. So I think that if there is a plan that the taxpayer will be home on the farm for these particular 6 months and they want to achieve a particular profit margin, for example, that would be much more likely to be considered a business than if the client just came home whenever he felt like it and didn't really have any plan on what he wanted to do with the farming operation. But the fact that he's only there for half the year wouldn't necessarily preclude him from being considered to be running a business. I suppose if you consider an example of Wet and Wild, a water park, that's probably only open a few months of the year when the weather is warmer, but it's quite obvious that even though the park might be closed for much of the year, they are still carrying on a business because they've got that significant size and scale and that profit-making intention. So it's definitely not precluding them from being a business, but it would just need to make sure that when the client is back on the farm, there is that profit-making intention and it's not just a hobby that he's carrying on when he's back home. Another thing to be mindful of is that if the business is only being running for half the year, you may need to look at a reasonable estimate of their turnover for the whole year for the purposes of working out whether they are a small business and whether they would meet the turnover threshold for the concessions. And it also reads as though there may have been a subdivision of the land to sell part of it. So it would also need to be shown that that part of the land which was sold was specifically used for the farming operation. So in short, it could be a business, but we just need to make sure that despite it only being run for half the year, that there is enough factors under the list to show that it is running a business. So I might hand over to Paul for the next question. And the question for Paul is, with respect to discretionary trusts, can a poorly drafted resolution containing ambiguity be rectified at a later date? And if so, how?
Thanks, Kate. This one caught me by surprise because it's not the question I was going to do, but I'll do it anyway. What this question really comes down to is an equitable doctrine called rectification. So rectification applies to lots of different avenues. Generally, rectification is mostly used where a mistake has been made and it is not the generally accepted outcome or I guess generally accepted agreement that was reached at the time. In this case, if it's a poorly drafted resolution and it's not what the trustee intended, and the conduct of the trustee after the resolution is consistent with, I guess, the true intention, then that will be good evidence that a document should be rectified. Generally, what would happen is a trustee would simply do a later resolution saying there was an earlier mistake or it was poorly drafted. This is the true intention. These are the steps we've taken subsequent to that, and they evidence what the true intention was. If the matter were such that it were before the Administrative Appeals Tribunal because of a objection to a tax decision, then you might take the step of going to the Supreme Court and asking for the Supreme Court to rectify, effectively put a stamp of approval to rectify that resolution. We've had circumstances where a trust deed was listed the wrong trustee of a trust. So a beneficiary was named in the trust deed. The old trustee was named. In that case, the court said, well, it's fairly clear that what the intention was for the trustee of the trust, whoever that happened to be nominated as a beneficiary. So in that case, the court said, well, rectification isn't necessarily required, but if it were, the court would have granted it. So look, the short answer is yes, it can be rectified. You may have to go to court if you're in a dispute with the tax office to get the court's approval to rectify it to what the true position is. And that's always a matter of looking at, well, what's the evidence to prove that the resolution was poorly drafted and they haven't simply changed their mind based on later circumstances. So I might, hopefully the next one, I'll throw back to Kate and give her this question.
All right, thanks, Paul. My short question is on whether a will needs to be registered. And the answer to that is no. There's no requirement in any state or territory in Australia to register your will. Certainly in New South Wales, there used to be a public register, but that ceased to be back in 2014. There are now some private providers of will registry services. However, even if you were to register your will with that provider, it's no guarantee that that was a testator's last will and testament. So there's no requirement to register it. We would normally just recommend that the original be placed in a safe location. And it's often a good idea to provide a copy to your executor or to your family members and to let them know where it is stored so that when a person does pass away, the will can be easily located because it will then be needed to be used for an application for probate. So I think I'm next handing back to Paul for his next question. And this question is on when a husband and a wife separate and do a family agreement to split the house, and then one dies before the split occurs, does the property then all go to the other spouse because it was still joint tenants before death? Thanks,
Kate. Yeah, this question or similar variants of this question has come up in a lot of recent one particular actual matter in a family circumstance where there was a property agreement reached. However, the person didn't change their will. They hadn't actually divorced their partner, and unfortunately, the client died. And notwithstanding the property settlement that had been reached, the will was still effective and gave all the assets to the ex-spouse and their child, who is not a child of the marriage, but a child of the deceased, was kind of left in limbo with, under the will, no assets going to them. And the question was, well, they've entered a property arrangement. How does that affect the will? And the answer, unfortunately, was that it didn't. So it makes for a messy situation where that child now has to make a family provision claim in order to get any benefit from their parent. Coming back to this question, where this is a very legalistic question or answer, in that because the property is a joint tenancy, in theory, the property goes to the surviving joint tenant and it doesn't pass according to the will. Now, it may be that the executor can make a claim in order to say that the document that they entered into, the family agreement or whatever that document is, evidenced an intention to either transfer, and it may have even done that even though the transfer hadn't occurred on title, and therefore that document should be enforced. We'd need to look a bit more detail at what the wording is, and it may even be that the document evidenced severing of the joint tenancy. So we would need to look at the detail of that document. Probably the takeaway from this question is that people who are separating need to put in place these documents, both a new will and obviously implement the documents that can be agreed to under the family agreement as fast as possible, because unfortunately we never know when death is around the corner. So it's a matter of certainly putting in place a new will, even while you're at the point of separating, so that your will isn't implemented in a situation where you don't want your spouse to receive the benefit from your estate. I can see a question come through, and it's about tenancy, so I might just quickly go to that and see how it works. Can we do a tenancy in common agreement even on the land title register if it is jointly owned property, so that half of the share of the dying person goes to a testamentary trust? Yes, absolutely. You can change the tenancy of a property from joint tenancy to tenancy in common. It can be done by one party unilaterally. They don't need the consent of the other. They do have to notify them, but they don't need their consent. And in that way, say for example, the job I was talking about, well, if she had have severed the tenancy, gone to tenancy in common, well, that asset could go into her estate, the half interest, and then go to a testamentary trust. So that can absolutely happen. Okay, I'm going to pass back to Kate.
Thanks, Paul. Sorry, I'm just moving across to the next question. Perfect, thank you. So is a copy of a will sufficient to be valid if you can't find the original? And this is somewhat related to the last question that I answered. And the answer is sometimes it can be sufficient, but there are a fair few hoops that you would need to jump through to have that copy proven as a person's last will and testament. So if a person is able to locate a copy, but they can't find the original, then the executor listed in that copy can make an application to the Supreme Court for a grant of probate. But the executor named would need to submit with that application an affidavit. And there's a fair bit of information that would need to be included in that affidavit. They would firstly need to set out how they found the copy, where it was located, whether it was electronic or whether it was a paper copy of the will. And then they would need to establish to the court that they had undertaken extensive searches to actually find the original will. So they would need to put in their affidavit that they had searched in the normal place where the deceased would keep their important legal documents. They would need to show that they had made inquiries with their bank to see whether it was held in a safe at the bank, for example. And if the will was prepared by a solicitor, the executor would also need to check with that solicitor or someone else from the firm to see whether they might hold the original will in their safe custody. And so that would all need to be included in the affidavit of the executor. If if the evidence shows that the will was last held by a solicitor, there would also need to be an affidavit from someone at that law firm, and that solicitor would need to let the court know what searches they had done to try and locate the original will, and also give some sort of explanation as to why the original perhaps had been misplaced or couldn't be located by them. The tricky bit when it comes to trying to prove a copy of a will is where the evidence suggests that the original will was last held by the deceased. And that's because there's a presumption that applies to say that if the deceased was the last person to hold the will and the original can't be located, that's because they intended to renounce their will by destroying it. So then further evidence would need to be put on by the executor to show that they never expressed any intention to go and change their will. There was no major change in circumstances, which you would anticipate there would need to be a change in will. So all of these things would need to be deposed to by the executor, and you would also need the affidavit from the solicitor. But if all of that can be shown, then yes, it is possible that you could have a grant of probate given over a copy of a will, but it can be sometimes tricky trying to prove that to the court. So I believe the next question we have is for Adrian.
Thanks, Kate. Question being from Warren Morrison. Thank you for your question, Warren. Can you give a rundown of the benefits and disadvantages of a complying employee share scheme? So Division 83A outlines the requirements to have an employee share scheme under the legislation. Practically speaking, we find it's really only utilised and benefited for really large organisations that run these schemes. In the private world, when you sit down and you go through it, then quite often there's issues in terms of the requirements, and you end up going down another road. And I'll come back to the reasons for that. But in terms of the benefits, I guess the main benefit, if you can fit within 83A, in tax deferral for the person that's receiving the shares, if they're received at a discount. And you're sitting, I guess, firmly within the legislation. So no issues in terms of debt equity rules, all of those sorts of things. One of the main disadvantages is that a person can only take up less than 10% of the shares under an 83A scheme. So that's going to limit some situations. And it has to be offered to 75% of employees who have been with the business for more than 3 years. So where you have the scenario where you don't, or you only want to provide it to a select few of key employees, then you're not going to meet that benchmark. So you won't fit within an 83A scheme. And also, I should say there are ways of addressing that in terms of who is issuing them. But that's really one of the main things that we see as a disadvantage in the private business world, because quite often you don't want to offer this sort of scheme to more than 75% or 75% of the staff that have been there for more than 3 years. It's also a requirement that they be at a risk of forfeiture. There are some changes coming through, or proposed changes coming through in relation to those provisions. One thing to remember is that there's also some different rules for what are called startup employee share schemes. So that's if we have a company that's been incorporated for less than 10 years and has turnover for less than 50 million, and we're giving them at a 15% or less discount. They are different rules. They're easier to comply with. So that may be an option for companies that are starting up, and you tend to see those in the IT world if you have IT clients. As I said, most times that 75% is a deal killer for the clients because they only want to give it to 1 or 2 employees. And then also the other issue of not taking more than 10%. So where you're using it as part of a succession plan, they're not going to be appropriate. Where you're using it to reward certain key employees, not going to be appropriate. So that's, I guess, a very short rundown on the benefits and disadvantages. There are a myriad version of different types of employee equity programs that you can implement. So it is more a case of talking to the clients about exactly what they want to achieve in terms of issuing this equity. That's my question. I know all of you have been waiting for Kim to grace us with her presence. I believe she's got the next question, so I'll hand over to Kim.
Hello. Hello. So my question is, can you access the small business CGT concessions on both an asset sale and a share sale? This person had a conversation with a related client who was adamant that their accountant was able to access these concessions on both an asset sale and a share sale for the disposal of their business. So simply speaking, you can access the concessions on an asset sale and you can access them on a share sale. When you are selling shares, there's some additional rules that you do need to meet in order to access the small business CGT concessions, along with a few modified rules of as if it was an asset sale. Some of those further requirements are that there is a significant individual, and that means that there's someone who has 20% of the voting rights, entitlement to capital, and entitlement to dividends. If this question is sort of in related to a company selling a business, so the company sells the business and it's entitled to use the small business CGT concessions, obviously if it meets all the requirements. And then a share sale was to occur, or we're trying to get out that money from the company. So the company is going to hold money in an asset revaluation account. And that money can only come out to the shareholder via a dividend, which means they're going to pay tax on it. And at that point, you can't use the small business CGT concessions if you're receiving that income. If, however, the company can be liquidated and it holds no other assets, there is a possibility that that untaxed portion of the sale can come out to the shareholders as a return of capital in liquidation. So it really sort of depends on what this question was trying to relate to. But yes, you can use the small business CGT concessions on an asset sale and a share sale. And there are ways that if the business is sold at a company level, that part of that gain on the company can come out to the shareholder and those concessions can be used again. That's the rest for that question. We've got Paul next, I believe.
Thanks, Kim. So this question is about owning a property investment in a unit trust, and that structure is extremely popular, but there are some pitfalls in it with reference to double taxation. Can you please highlight on these and advise how to overcome it, or perhaps another structure to consider? So obviously, what this question is getting at is CGT event E4. And what that CGT event, it only relates to unit trusts or trusts with unit holding entitlements. It doesn't apply to discretionary trusts. And what that CGT event is about is where a unit holder in a unit trust obtains a non-taxed amount, effectively a capital amount, in relation to their units. When that happens, what it usually takes into account in these circumstances is the small business 50 concession under the small business CGT concessions. And what happens in that case is the amount that comes out as capital for the small business 50 concession comes to the unit holder. What it will do then is reduce the cost base of the units for that unit holder. And if the cost base is reduced to zero and there is anything left, then that amount will be a CGT or capital proceeds from CGT event E4. So if we took a scenario where a property investment unit trust was established with, a number of unit holders, each holding 10 units worth $10 for a dollar a unit, and they were able to claim small business concessions, and out of that they received $100,000 untaxed because it related to the Small Business 50 concession. In that case, their cost base would reduce to zero from $10, and the difference between the $100,000 and the 10 is a capital gain. So that is one of the the difficulties in having property in a unit trust or a fixed trust. What are the alternatives? Well, a hybrid unit trust that has both discretionary and fixed entitlements can be used to avoid CGT event E4 occurring. And what that means is that if the distribution of the capital gain on a sale of the property is made using the hybrid provisions or the discretionary provisions, then in the same way as a discretionary trust, CGT event E4 just does not happen. That is one way to get around that problem. One of the issues, obviously, is if you have a unit trust that is not hybrid and you already own property in that trust, well, you might look at whether or not you were able to vary the trust to introduce those discretionary elements. It will depend heavily on, I guess, on the terms of the variation clause and whether that is possible. But that may be an option. In terms of other structures, I mean, the reason people are using a unit trust in this scenario as opposed to a company is probably twofold. One, principally, is the CGT discount, and I guess conversely to that is the tax rate for companies. If it's purely a investment property that generates rent and no other business assets, then it's going to be taxed at 30%. Principally, people will use a unit trust for the reason that they want to save that tax differential. You're not going to avoid that, but perhaps the better structure is a hybrid unit trust. The other difficulty with unit trusts in this scenario is in terms of losses. There are extra tests that need to be met in terms of non-fixed trusts, which are hybrid trusts, or even most unit trusts might not be a fixed trust. They are non-fixed trusts. There's a number of different tests that need to be met. So yeah, that's I guess in wrapping up that question, a hybrid unit trust, if you're looking to invest, is one way. The other alternative is a company, but obviously there are greater tax downsides to owning a purely rent deriving asset in a company. I'm going to pass over to Kate for the next question.
Thank you, Paul. Okay, so this LRC member has a client who passed away, leaving her 4-year-old and her unit in the care of her mother as per her will. The unit's rental income was to provide for her child under the will, and their biggest fear is that the paternal father of the 4-year-old would try and get custody of the child and try and claim the unit. At the time of her passing, he was living in Melbourne, where he has other children, but has since relocated to Queensland. And the question is, how do we protect the child and the unit from the paternal father? I should just clarify, I've had some further information on this one. Under the will, the client left her unit directly to her 4-year-old child, and she had appointed her mother as her executor. So because the child is only 4 years old, under the will, the mother as the executor would be responsible for holding that unit on trust for the child until the child turns 18 or 25 or whatever the age might be specified under the will. In terms of the paternal father potentially accessing any part of the unit, if the estate is administered in accordance with the will as it was drafted, then he wouldn't have any entitlement to either the capital or the income from the unit. That would be transferred to the mother to be held by her as trustee for the child, and the income would be applied for the benefit of the child for school fees and other expenses which might be incurred for the child. Because the paternal father, there's the possibility that he was a spouse or a de facto partner of the deceased, there is unfortunately always the possibility that he could get upset with the fact that he wasn't left any part of the unit, and he may decide to commence a family provision application. And because he would have that relationship with the deceased, there is unfortunately nothing that you can do to stop him from making that application. So then it would be in the court's hands to look at whether a fair provision had been made for him under the will, and if not, whether there should be an adjustment in his favour, whether that be for part of the unit or for some other asset forming part of the estate. And that would depend on a few different factors, such as the relationship between the paternal father and the deceased, as well as his current personal and financial circumstances. And given that it was left for the benefit of the child, it's probably unlikely that an adjustment would be made in his favour, but it certainly is a risk and something that could occur. It's these types of situations where we would often recommend that a person implement a testamentary trust and maybe even look at using our contractual will strategy, because unfortunately, once a person has passed away, there's little we can do to change that, and it is at the whim of the court as to whether there is an adjustment. So certainly it's ideal to get your affairs in order before a person passes away. In terms of the custody question, it's not an area that we practice in, but I do understand that if there had been a formal separation between the client and the paternal father, the family court may have made a direction as to who would look after the child if one of the parents were to pass away. If such a direction wasn't made by the court, then it may be the case that the grandmother of the child and the paternal father would need to submit an application for custody, and then it would be up to the family court to decide which application would be more in the interests of the child, whether that is having the custody with the grandmother or with the paternal father. But as I mentioned, not something that we deal with on a regular basis. And if that were to become an issue, you would likely need a family lawyer to give advice on that matter. But yes, I think I will next pass back to Paul for the next question.
Thanks, Kate. The next question really relates to Division 7A, and I'll try to cut it a bit shorter. Essentially, there was a Division 7A loan made in an earlier year when there was no distributable surplus in that company. And they're looking at, well, what happens in future years when there is a distributable surplus? What happens to that loan? Does it stay on the books of the company? Do they have to pay interest? Do they have to repay it at all? And other things like, well, what can we do with that amount? Is a separate credit loan from the shareholder, for example, can that be on the books, or should it be reduced by the amount of the debit loan owing by that shareholder? The first thing to say is that Division 7A will apply when a loan or payment is made to a shareholder. We know that, but it is limited to the amount of a distributable surplus of the company. The first question whenever this scenario gets raised with me is, the first thing I say back is, we need to be 100% confident that there was no distributable surplus, and that we look at the definitions of what distributable surplus includes, rather than simply saying, looking at a purely asset and liability basis. So we need to make sure that we are confident that there was no distributable surplus. If we're confident that there was no distributable surplus, then 109G3 says that if a later forgiveness of that loan occurs, then it will not be a deemed dividend for forgiveness. What that is really designed to do is to say, well, if a deemed dividend occurred in an earlier year, we're not going to double tax it. Now, the difficulty is that the earlier deemed dividend, which was the loan, wasn't taxed because we didn't have a distributable surplus. However, that is a quirk of the law at the moment. It is one of the areas that they have suggested will be rectified to say that a later forgiveness of an earlier deemed dividend will be taxable if the earlier deemed dividend wasn't taxed, probably because there was no distributable surplus. So when those changes come through, that is said to be one of the changes that is being made. So that kind of leads us to the question of, well, what do we do about that loan? At the end of the day, it is a loan by the company to a shareholder or a related party of the shareholder. Therefore, it has to stay on the books unless something else is done. Whether or not repayment is required or interest is charged is a matter for the company. And in a private family company setting, it will generally be a interest-free at call loan. Directors of the company obviously have duties to the company in order to maximize profits. So in a more widely held group, it may be that the directors, if they were fighting with a minority shareholder, for example, should be charging interest, and perhaps that might be a point of contention. But in theory, if the company says that no repayments are required at this point and no interest is payable, well, that's for the company to decide. But until something happens, that amount is repayable. If the company were to go into liquidation, that loan would be called up by a liquidator, and that's often something that is forgotten or not thought about, and needs to be reconsidered, particularly if companies are going through rough times. Obviously, bearing in mind, if you did forgive the loan, well, that might be a point of issue in a liquidation. But from a strictly Division 7A perspective, if there was no distributable surplus in the year in which the loan was made, a later forgiveness of that loan will not attract any Division 7A consequences. The question at the bottom says, will the commercial debt forgiveness rules apply? Whenever a company forgives a debt, we need to look at the commercial debt forgiveness rules. In general, the commercial debt forgiveness rules don't generally apply to Division 7A loans, purely because the loan is paid to a shareholder, generally for private expenses that are non-deductible. So that is one of the first step of determining whether it is a commercial debt forgiveness. Now, if there was a Division 7A loan to put into a business, well, that would be a different story, and the commercial debt forgiveness rules might apply. So I don't, even though I've said you would be able to forgive it, it's not something to be done lightly, purely because we need to make sure that we recap and go over again whether the distributable surplus calculation is correct, and make sure that we're doing all of the steps that need to be done in order to be comfortable that no tax consequences would arise from a forgiveness. But in theory, yes, the Division 7A won't apply to that subsequent forgiveness. I'm going to pass back to Kimberley, who's going to take the next question.
This is not the question I was expecting to receive. So this question says, assume the following company tax returns for the 17, 18 and 19 years are prepared under which income tax is payable. The company has money sitting in the bank available to meet the tax assessments. The company tax returns are lodged with the ATO in October 2021, and the resulting tax assessments have not yet been paid by the company but will be shortly. Is the company able to declare a fully franked dividend between assessment and payment, or only once the tax has been paid? So in order to get a franking credit as a company, you need to have paid the tax, which means if you haven't paid the tax, you won't get the associated franking credit. if you do have sufficient franking credits to pay a dividend and those tax assessments haven't been paid, then you still can declare that fully franked dividend. But it's probably unlikely if you haven't paid your tax returns that you're going to have sufficient franking credits to allow it. It's really once the tax has been paid that you can access those franking credits.
I'll jump in because this isn't on my list either. So there's some surprise questions popping up through today. Really, it's a question here of whether or not the company would go into a franking deficit situation, which is obviously something we want to avoid. Often these questions arise in that first year of operation. In this scenario, it may be that those 18, 19 years were either non-profitable or loss years, in which case there would likely be no or insufficient franking credits to pay. If they were either lodging and paying their tax, then there would be sufficient franking credits. If they're paying, installments and they have made the installment payment, then the franking credit should arise. Really, it's a question of what does the franking account look like, and then working your way through whether or not it would put the company in a franking deficit situation. There is the ability to pay a franking deficits tax, which is kind of like a prepayment of that tax. But that actually can lead to some anomalous situations where you can actually end up losing up to a third of your franking credits as a result. So the short answer, unfortunately, sometimes is they need to pay their tax and pay the dividend after that. It may be that they can make a payment, which would be a Division 7A payment, and then later offset it against the dividend that is paid at the right time. That would probably be the answer that they would have to undertake. This is the question Kimberley wanted, so I'll throw back to Kim.
All right, beautiful. So this question is evaluation of the goodwill in a business, it's a two-part question, so I'll start with the first part, which is evaluation of the goodwill in a business required for a 122-5 rollover? And with regards to the 122-55 or 60 rollover, where the goodwill is a pre-CGT asset, is the goodwill included in the total market value of all assets? So this question is relating to the Section 122A rollover, which allows an individual or a trust to dispose of a CGT asset and utilise the rollover in this section to defer any of the capital gain. So Section 12250 is in relation to when all of the assets are a post-CGT asset. And so in this circumstance, you don't need to get a valuation of the goodwill because the calculation to determine what the cost base of those shares are that you are receiving will be the market value of precluded assets. And precluded assets include your plant and equipment, office furniture and inventory. And then the calculation looks at the cost base of the goodwill or the other CGT assets. So in that circumstance where all the assets are post 1985, then you don't need a valuation of the goodwill. In the second half of this question, when we look at section the 55 and 60, this is to do when all of the assets are either pre-CGT assets or there's a mixture of both. And in those circumstances where you have assets that are a mixture of post and pre-CGT, then you will need to get a valuation for the goodwill component because it is included in the total market value of all assets. Similarly, if it did have plant and equipment in it as well, you're going to need that goodwill market valuation to apply that proportionate calculation. That's going to come into sort of the next question, because when you've got that calculation of pre-CGT assets and post-CGT assets, there's going to be a proportionate of the shares that you receive because of that rollover. Proportion amount of those shares are going to be pre-CGT shares, and a proportion of them are going to be post-CGT shares, depending on the total market value of all of the assets transferred or disposed of. So the second question is, are pre-CGT shares acquired under the section 122-55 or 122-60 rollovers transferable? And what are the CGT implications on transferring such shares? So once you own these shares, whether it's the original interest shares or the consideration shares that you received for transferring the asset, you can then transfer those shares to another entity or a third party. So if you've got a third-party business sale and you're selling all your shares, they definitely can be disposed of. The CGT implications on disposal are going to differ depending on if all of the assets were pre-CGT assets. And if that's the case and they all were pre-CGT, then the shares are all going to be pre-CGT assets. And so any gain or loss on the disposal is going to be disregarded. If some of the shares or if some of the assets that were transferred were post-CGT assets, then as previously said, there's going to be a proportionate calculation based on the total market value of all assets. And that means that some of the shares being sold will be pre-CGT and some will be post-CGT. So that's going to have a look at the total price received for those shares and allocating, a price per share received. Any share that had a pre-CGT status will, disregard any gain, and any gain or loss on the shares that are post-CGT considered will have a capital gain or loss to be paid. And we've got the next question, which is over to Kate again.
Thanks, Kim. Okay, so a hot question at the moment is whether there's any update on where the Division 7A proposed changes are at and any idea of when the changes might become effective. It's quite a well-timed question because there was actually a draft taxation determination released by the Commissioner 2 days ago, this Wednesday. I have uploaded as a file a copy of the determination. So if you're interested, please feel free to download that and have a read. But it was released as a draft determination. So as they often do, the determination has now gone out to the public for comment. So they're looking at, in the determination, when there might be financial accommodation provided by a beneficiary to a trust. And under the determination, they have set a tentative date of 1 July 2022, in which these changes would become effective. So nothing will change for the current 2022 financial year, but potentially for the 22-23 financial year, this could have come into effect. In terms of timing, they have requested that any comments be submitted by the 8th of April, and we're still in the course of reviewing the determination. We might, as a firm, come up with some comments and send that off to the ATO for them to review. If we do prepare a submission to them, we will forward that to all the LRC members so that you can see our thoughts on the draft determination. And depending on how those comments go and when the formal determination is issued, we might look to put on another webinar just addressing those changes. So please let us know if you would be interested in hearing about those changes. And as I mentioned, please feel free to have a read of the determination at your leisure. The next question we have is for Adrian, so I'll pass over to him.
Thanks, Kate. I recognise there's not much time left and still a couple of written questions to go, or pre-submitted questions to go, I should say. So I've seen a couple come in on the chat. We won't be able to get to those during the presentation today within the hour, but we will go back to those persons separately. The question I've got here is there's been a number of cases recently regarding the question of contractor versus employee, such that traditional treatment by the ATO may be changing. Have your views on the current state of play regarding this topic and whether we should be advising on clients the old interpretation by the ATO may change? I think the short answer is yes, and it's not just the ATO, it's also the OSR who are changing their approach, and particularly in New South Wales and Victoria, been some cases in relation to medical practices, optometrists, and there is an upcoming New South Wales OSR revenue ruling which will, in essence, flip a lot of medical practices on their head as to the ways that they are treating for payroll tax their contractors, so to speak. Recent High Court decision in Gemesk, which I guess kind of went a little bit against the grain, but it is a hot area. It's an area the ATO and the OSR are very interested in, so we should certainly be cautious in reviewing our clients' situations. I'm going to hand off to Paul again, I believe.
Thanks, Adrian. So the next question, which I will click, relates to our secured debt strategy, which involves an individual transferring money to a trust. They might use a check or a bearer promissory note or even cash, and using that as a asset protection device. The question is there any danger that a gift would be treated as another settled sum of the new trust and preclude them from being a beneficiary? The short answer is no. Provided the trust is established by someone other than that person, there is really what this question is about is making sure that the trust is not what's called a revocable trust under the 1936 Tax Act. In that legislation, it says a trust established by the person. In this case, if we established the trust and I was the settlor, which I generally am in most of our trust deeds, I'm the person who establishes the trust, and therefore anyone who contributes trust property to that trust that I created does not come within Section 102 of the 1936 Act. There is a case from many years ago called Truesdale versus the Federal Commissioner of Taxation, which supports that, and that was the argument that any contributions by family to a discretionary trust established by their accountant, the Commissioner wanted to treat that as a revocable trust under Section 102. The benefit of that to the Commissioner is that he gets to assess that trust, any trust income, at the highest marginal rate. And the federal court in that case said no, contributions by a family member to a trust that they control, which was set up by a third party, is not a revocable trust. So again, short answer to this question is no. And I think the last question is from Kimberley.
I'll try and keep this one short for you. But the question is, there appears to be movement to changing the vesting date of a trust by relocating that trust to South Australia jurisdiction for existing trusts, or just choosing South Australia for new trusts. Is this a problem? Is it that easy? And do you need to change other provisions of the deed? What are the stamp duty issues? Do you stamp the trust? With what jurisdiction? It was said that you need to stamp the deed in the state of the trustee company is and not do anything in South Australia. Can you have the trustee company in South Australia if you're in New South Wales? And if so, what needs to happen? Is the registered address enough even though all the members are in New South Wales? This is a question I personally ponder quite a bit with the vesting date rules. At this stage, it's really quite unknown what's going to happen in this area. If we look at the proper law of a trust and the trustee can tell you what jurisdiction that's going to govern the law, and you could technically choose South Australia as the jurisdiction and governing law. That would mean that it's a South Australian trust, even though all the members of it are in New South Wales. But when it comes down to trying to avoid that vesting date, we just don't have any case law at the moment concerning trying to change it to South Australia and trying to deflect where the administration of the estate's occurring. So if all the administration of the estate's in New South Wales, but you've chosen South Australia as a jurisdiction, we don't have any cases of someone trying to say, no, you can't do that, or yes, you can. I envision we might see some movement in this because, a lot of trust vesting dates are coming up and trusts are becoming a really popular method to hold entities. I would think that the ATO at probably some stage is going to bring a claim for a trust that says, it has vested. And, once a trust vests, you've got this, income tax and CGT events that happen on that vesting for all the income and capital of the trust. So really the short answer is we don't know yet, and hopefully we'll get some movement on it in the future. And I'll pass back over to Paul, who's just popped up.
I'm actually going to pass over to Adrian, but I guess we can all come back on the screen. But I'll hand over to Adrian, who's going to close today.
Thanks, Paul, and thanks to everyone for coming along. Your feedback questionnaires will be out in about 10 minutes or so. We take everything on board. For the questions that were submitted during the presentation that we didn't get a chance to answer, we'll go back to those people separately. In terms of our next presentation, it will be on the 25th of March, and it's going to be covering off on CGT small business concessions. So the sort of things we're going to go through is when is the right time to use them, getting a cost base uplift using Division 152, issues to consider when moving the assets and options for restructuring into separate companies, whether the asset's actually active or not, and getting the money to the individuals at the end of the day. So hopefully you can join us. I'd like to thank our presenters who adapted to the mystery questions very well, I thought. Certainly, it wasn't a charade on our part. They were definitely questions without notice. So thanks to everyone, and thanks for everyone for coming along today.